So hi, everyone. I'm Harkirat. I'm a senior at Harvard College and one of the co-chairs for the India Conference at Harvard. We hope you've had a great time so far listening to panelists on a variety of topics, from healthcare challenges to democratic challenges to art and culture, just a whole host of topics. And now, before we conclude our first day of the conference at HKS, it is our honor and privilege, really, to have a keynote address by Justice Bhat from the Supreme Court of India. And just a little bit more about Justice Bhat's career. Justice Bhat completed his LLB from Campus Law Center, University of Delhi, and enrolled as an advocate with the Delhi Bar in 1982. He thereafter practiced and was enrolled as an advocate on record in the Supreme Court in 1989. His practice predominantly comprised of public law, employment education, and constitutional disputes. He became the Chief Justice of the Rajasthan High Court in 2019 and was also elevated to the Supreme Court in the same year. He will demit office in 2023. In his career, Justice Bhat has delivered key judgments in several areas, such as right to information, capital punishment, validity of constitutional disputes, intellectual property, arbitration, IBC, tax, and insurance. In addition to this, Justice Bhat also chairs the Juvenile Justice Committee of the Supreme Court, which periodically monitored actions by state agencies for the speedy rehabilitation of orphan children during the COVID-19 pandemic. I would also like to introduce Mr. Hitesh Hathi, who's the Executive Director of the Lakshmi Mittal Family and Family South Asia Institute at Harvard University. He will be moderating the Fireside chat after the keynote address. Mr. Hitesh Hathi is the second Executive Director of the Institute at Harvard. In his role, he's responsible for working with faculty at Harvard to find new innovative connections to deepen our engagement with critical issues in the South Asia region. He received his Master's of Art degree from Harvard in Sanskrit and Indian Studies and was a PhD candidate at the Department of South Asian Studies here. So without further ado, I would like to welcome Justice Bhat on the podium. Thank you so much.
Very good evening to all of you. I would firstly thank the organizers for inviting me to this special 20th edition of this conference. In this gathering of people from different fields, be it in the arts, politics, business, or law, this allows me to pose a simple question. What is the relevance of the Constitution to each one of us? I'm sure that for some of you, this question evokes memories from history and the humanities classes in school. The reputation of the Constitution as a blueprint of our legal system endures. However, to think of it as a mere document is to severely underestimate its significance in the lives of each one of us present in this room. The Constitution contains the aspirations of its framers for the vision they held for the future of our republic. It empowers individuals by guaranteeing certain freedoms, such as equality, speech, expression, faith and religion, and non-discrimination as fundamental rights. It provides guardrails for the state in its exercise of power and delineates remedies for its breach. It therefore binds each one of us to this entity which we call the state, comprising of all our elected representatives and not just those who constitute the executive government of the day. And it fastens upon them the mandate of materializing our aspirations or collective will as the elected representative. Our Constitution was born out of a struggle which was no less than a revolution. Freedom came at a terrible cost of the horrors of partition. When we gained independence, we were in no shape or form a united nation. We were a mass of fragmented princely states riven with caste, class, and other sectarian forces. Our populace was unlettered, hungry, and united in their craving for a better future with the security of basic comforts. The Constitution demonstrated our first concerted effort in independent India to reform our social system by outlawing centuries of subjugation, not only from the British, but also from our own inherently unequal social stratification. It enabled us to dismantle the monopolization of power and resources from the hands of the few and distribute it amongst the many. The essence of this endeavor is captured beautifully in our preamble, which mandates that we as the people have given unto ourselves a democratic republic tasked with upholding justice, liberty and equality and fraternity for all citizens. What are the challenges that face us in this implementation, and how do we see its development in the next 25 years forms part of my conversation with you all today, in the hopes that we reflect upon these concerns well after this conference concludes. The first is democracy. Elections which are free and fair are the only mechanisms in a democracy such as ours, where the voiceless, that is empowered, and the poorest have the right to vote, equally with the mightiest, the richest, and the most influential voters. Elections have the power to bring seismic changes in the quality of lives led by the many. A conscientious government working towards the betterment of historically repressed sections of society has the ability to advance their social progress by decades within a short span of 5 years. We must endeavor to ensure that the dance of democracy is not reduced to a cacophony of senseless noise. The Constitution has guaranteed that there is dynamism in our governance, and of questioning policies, politics, and accountability exist. It is the wisdom of our Constitution makers that has ensured that democracy is the governing ideology, which acts as a channel for all ideas, experiments, and debates. Two vital achievements of Indian democracy are the grant of universal adult suffrage and the constitutional entrenchment of our election system and the mechanism to conduct free and fair elections. The grant of universal franchise was a radical choice. To put things in context, the United States of America enfranchised all its people, not through its constitution, but through a law, the Civil Rights Act in 1965. Women too received that right only in 1920, about 143 years after the Declaration of Independence. That all adult Indians were to be equal voters was a radical aspiration to have given the social and economic inequalities that characterized Indian society. While the commitment to prepare electoral rolls on the basis of universal franchise was fairly unanimous, the practical challenges proved to be many in a deeply hierarchical society divided by caste, class, religion, and language. The initial experience of enrolling 173 million people, of which roughly 85% were illiterate, is what prompted the Constituent Assembly to include a single unitary election commission in the constitutional scheme. That aspect is perhaps not studied or celebrated as much, but it is a matter of pride that our system has by and large worked smoothly, where the largest number of people exercise their right to elect those who govern them with unfailing regularity. The complications of a complex voting system, which exists in other democracies, with bitterly contested results, does not haunt our country. The framers of our Constitution wisely created the Election Commission as an independent organ, which is the final arbiter on how elections are to be conducted each year, from the fixing of the schedule to the declaring of the result, to even intervening and controlling electioneering ground rules. The courts have also played a supplementary role, in ensuring elections are free and transparent. Every election candidate is now obligated to declare their personal assets to the voters to enable them to make an informed choice. Citizens have the option to vote for a none of the above, or what we call as nota, when they feel unrepresented by electoral candidates. It has ensured in a series of judgments that the Election Commission remains an impartial and an unbiased empire that has plenary power to oversee elections in India, free from interference. The court has laid rules which apply when ruling parties and coalitions split, leading to spells of political instability in several states. These rules and checks it places on the center's power to invoke emergency powers to dismiss elected state governments or dissolve state assemblies has dramatically transformed political behavior and brought in stability in governance, besides prescribing rules that are to be followed in exceptional situations by constitutional authorities while exercising powers. Our citizens' wisdom has been shown repeatedly in the conduct of peaceful handing over of power in these 7 decades. during the 18 general and innumerable state elections, an achievement that overshadows the bitterness and violence exhibited in so-called more mature democracies which have witnessed lawlessness and violence. While it is the duty of those vested with the responsibility of ensuring free and fair elections to always safeguard the exercise of the vote by the common man, it is also the responsibility of the voters, the electorate, to be alive to their duties, the constitutional rights to make inquiries that allow them to exercise such rights to the best of their abilities and always question what impedes it. This is the beauty of a functional democracy. There is an inherent awareness that the fundamental block of democracy is the power of the people, who periodically exercise their freedom of choice through the mechanism of elections. Faith in the democratic system and its fairness is what brings people to queue up at the polls every 5 years in a bid to influence their material and social development. This political right to choose one's government is what has a cascading effect on all rights that the Constitution guarantees to its citizens. The second is equality and justice. On the eve of independence, India was a country that was left ravished by famine, malnourishment, and utter poverty, where individuals faced stark inequalities, both material and social. Deeply aware of this reality, the Constituent Assembly members envisioned a radical transformation for its people. The Constitution, therefore, by intentional design, is seeped in the values of justice, political and social and economic, and equality, which can be understood as two sides of the same coin, to remedy this historic injustice and inequality. To fulfill the objectives of the preamble, the Indian Constitution, along with fundamental rights, provided for directive principles of state policy, beginning with the obligation on the state to promote welfare, social and economic, of the people by reducing inequalities in income, facilitate opportunities for individuals and groups. These directive principles also ensure equal justice and free legal aid, provide for right to work, to education. They protect the rights of workers by giving them humane work conditions, living wages, participation in management of industries, and maternity benefits. They also provide for protection and promotion of educational and economic interests of historically oppressed sections, that is, scheduled castes and scheduled tribes and other weaker sections by the state. Although these principles are not enforceable, they are an articulation of a commitment to a welfare state. And in that sense, this is what sets it apart from other constitutions, because more or less constitutions encapsulated a status quoist society. The implementation of these directive principles can be seen in numerous amendments to the Constitution and formation of various legal statutes. For example, the Constitution was amended in 2002 to include the fundamental right to education for all children. The Food Security Act recognizes the right to food, provides for child integrated services scheme, maternity entitlements, and midday meal schemes. While we have radically opened up our markets, the state's presence persists in these areas of food security, employment, education and health, etc., despite increased privatization of our economy and society. This role is essential given the welfare direction that our Constitution enjoins the state to perform. The role which the state discharges in most parts of the economy is now more of a facilitator or regulator than as a participant. Our Constitution embodies, in effect, two integral facets of equality. One is right of all people to the benefits of society without discrimination, the right to equality of opportunity, and the second is the positive right that facilitates equal access. At the first appearance, both seem indistinguishable. Yet a closer look shows them to be different in shape and content. The right to equality in the first sense is a formal one, which is that all human beings should be treated alike. Here we talk of benefits, of public goods, of services, and other rights, which every citizen of a modern state can expect. The equality of opportunity here presupposes that there is a right to claim, which everyone has. Thus, the right to claim public employment, the right to claim entry into public spaces, admission in public institutions of learning, etc., should not have any barriers based on caste, race, gender, religion, place of birth, etc. Here, we took a cue from the United States, which did not have such nuanced rights, and our Constitution speaks of this. And there are special provisions for women and children, which enable this kind of positive discrimination. This is the right against discrimination, which is not merely in respect of public institution, but also in access to facilities that are publicly available. A powerful injunction is reiterated in the explicit outlawing of untouchability in all forms. Therefore, this is the second aspect, the positive or transformative part, which underscores the societal resolve to eradicate the inhumane casteistic practices. The substantive equality part, or the positive part, mandates acknowledgements of disadvantages suffered to ensure that existing barriers are addressed by innovative state intervention through laws and policies to guarantee that the largest number of people benefit and partake in the progress achieved. It is this aspect of equality which needs to be carefully addressed. Here, equality is a work in progress because a large segment of our population's basic needs to be fed, housed, educated, and clothed, and provided with a modicum of meaningful livelihood is still unmet. Much has been done, but we have greater distances to cover, both economically and socially, if the poorest in our country are to be considered equal in value to the mightiest. Apart from these powerful ideas embedded in the provisions relating to equality and justice, the Constitution also guarantees rights to freedom of speech and expression, of association, of movement, of settling down anywhere in the country, of religion, of faith, trade, business, and commerce. A transformative reading of the Constitution in line with modern times has ensured that other facets of bodily autonomy, reproductive rights, the freedom of choice of spouse or partner, choice of clothing, diet have also been recognized as a result of litigation by the courts. These are now every citizen's rights, violations of which can be redressed judicially when individuals exercise their fundamental right to judicial remedies. The right of expression to discuss and dissent has been part of our constitutional culture and lies at the heart of democratic discourse. The power of art, whether it is theater or films or songs or cartoons or even satire, to disseminate ideas is compelling. If these ideas are not acceptable to the influential and the powerful, they attempt even in democracies to muffle them. From prohibitive policies that limit the number of pages in the newspaper to internet shutdowns, Indian courts have mostly acted to protect this invaluable right, which can be asserted as long as they are peaceful and do not lead to disruption of the public. Challenges to this can be either overt or indirect, both of which are protected against. The right to voice protest and make demands lies not only on the as part of the right of free speech and expression, but also as a valuable right to association. Rights and benefits enjoyed the world over and have been a direct result of this. Democratic decision-making has accommodated and very often been preceded by demands, protests, and mass movements. As long as they are peaceful, the exercise of such rights is necessary and acceptable, because this is how people collectively speak to power, whether through agitations of workers, chambers of commerce demands, or those of trade bodies, students' organizations, or decentralized social movements, such as those which have led to the creation of new states, setting up of industries, or schools or universities, or granting concessions. The exercise and assertion of these in our democratic experiment has enriched public discourse. In today's age and day and age, which is characterized by easy and rapid proliferation of media via the internet, a retreating state, and an overwhelming level of privatization. This freedom of speech and expression faces far more insidious and indirect challenges. The absence of more stringent regulation or a framework of law that regulate control and ownership of media houses has unfortunately meant that private interests are having a chilling effect and beginning to dictate what is reported on in a newsroom. The ease of disseminating information in media has been a double-edged sword. It has led to a democratization of voicing opinions by providing an accessible platform, enabled cross-jurisdictional dissemination, debate and protest, and unprecedented access to knowledge. But it has also made the spread of fake news and false narratives and hate speech that much more easier. It is imperative for us to protect and promote the former and direct concerted efforts in the form of legislation, in its absence, judicial intervention to tackle the latter. Moving on now to fraternity, I believe that the value of fraternity has not received its due share in the public discourse. Our Constitution envisions fraternity on two levels. One is on the macro level between the union and state governments to function in a cohesive manner for the smooth administration and governance of the country. But the other, more importantly, is at the micro level, a bond of brotherhood between citizens. It may seem like a euphemistic ideal, but to the country, fraternity regulates political and social institutions and encourages a social consciousness into our democracy. It stokes the intrinsic need in us humans to reach out in times of celebration and especially in times of distress to ameliorate suffering. We set aside our differences in the latter and work towards the collective upliftment of all, as we have witnessed in many episodes of kindness and generosity during the COVID-19 pandemic. Fraternity is linked to liberty and equality is inextricable, as it reinforces the need to treat everyone as an equal, worthy of respect, so as to ensure, in the words of the preamble, dignity of the individual and unity and integrity of the nation. In our pluralist society, the polyvocality of its members is an asset that strengthens our democracy. We may find ourselves in different positions on the spectrum of political ideology, but it is fraternity that entrenches our belief in certain fundamentals such as respect for the rule of law, which are indispensable for unity. This births the value of tolerance, which unfortunately has been dwindling the world over. Fraternity is not the assimilation of the minority into the majority. To the contrary, it is the celebration of peaceful coexistence of differences that constitutes our national identity. The weaponization of these diversities to flame tension not only promotes mistrust and destroys unity, but weakens the powerful precept of oneness, inclusiveness, humanism, and the idea that not only are we equal and we should have access to equal opportunities, but also that we all stand together and for each one of us, irrespective of polity, social hierarchy, religion, origin, or region. As our great philosopher, statesman, Dr. Radhakrishnan put it, India is a symphony where there are, as in an orchestra, different instruments, each with its particular sonority, each with its special sound, all combining to interpret one particular score. It is this kind of combination that this country has stood for. Fraternity is the buckle that fastens liberty and equality. The preamble did not originally contain the expression fraternity. It was inserted later by the drafting committee under Dr. Ambedkar, who put forth eloquently on the floor of the assembly that liberty, equality, and fraternity form a union, a trinity, in the sense that to divorce one from the other is to defeat the very purpose of democracy. The right to equality, sans liberty or fraternity, would be chimerical, as the concept presently known would be reduced to equality amongst equal in every manner, a mere husk of the grand vision of the Constitution. Likewise, liberty without equality or fraternity can well result in the perpetuating of existing inequalities, and worse, result in license to indulge in society's basest practices. The practice of fraternity, therefore, without using that expression, is perhaps best embedded in our tradition. As many reformers and spiritual leaders have emphasized, the oneness of all faiths and the affinities which each human has to the other. Our traditions, such as celebration of religious festivals, our Sufi tradition, coming together during a calamity such as cyclones or earthquakes, where places of worship like temples, gurdwaras, mosques, and churches have been thrown open to care for the homeless, the sick, and those needing shelter, are a testimony to the living idea of fraternity. Today and these days, there is need for consciously fostering fraternity, which underscores that essentially we are all humans and need to reach out and sustain each other in a common community with shared goals, and that without this togetherness, society can descend to sectarian chaos. Fraternity reminds us that despite our diversity and our claims to identities, we have to celebrate being together, stand for each other now and always. Additionally, the benefits of investing in an atmosphere conducive to fraternity go beyond the realm of social justice. Fraternity operates as an insurance for economic gains. A peaceful country provides much needed stability that inspires investors' confidence, fosters growth in the economy. This consequently serves as a marker for gauging the progress of the nation. Thus, there is an obvious positive impact on even seemingly disparate sectors in the strengthening of this constitutional value. The values of justice, equality, liberty, and fraternity do not exist in silos. Together, they manifest the principle of fairness, reasonableness, tolerance of plurality, a framework of checks and balances that rules out favor, excess of power, which forms the planks of on what all interactions are based. This is what binds each of us, despite the diversity of vocations we practice with one another and with other Indians that do not form a part of this audience. The commonality that is each of us has an engagement with the state. We are in constant dialogue on a daily basis, and our concerns and aspirations are affected by state policy. Constitutional culture is how the state accommodates these different interests and how, as an informed citizenry, we can keep them accountable. Every election season, politicians approach us with many promises of maximum good for maximum people. But an aware citizenry enjoying this country's vibrant constitutionalism must notch up all the pluses and minuses, and at the end of the day, square them up to see whether the government lived up to its promise and where it faltered. When democracy is functioning for most, it becomes white noise, a background score to our daily life. However, when it is faltering, we realize its tenuous and fragile position. Therefore, a constitutional culture requires intentional efforts towards being consistently fostered and nurtured. In a seminal constitutional law judgment, the Supreme Court had reason to express this sentiment, that the mere existence of a constitution by itself does not ensure constitutionalism or a constitutional culture. It is the political maturity and traditions of people that give meaning to a constitution which otherwise would merely embody the political hopes and ideals. This is what the democratic ethos of our constitution expects of us. An illustration of fostering this culture is demonstrated by the state support of various facets of our society, such as fine arts and culture, which in pre-independent India enjoyed royal patronage. In the Indian state from its inception has remained committed to this goal through disbursement of public funds to setting up of dedicated institutions that foster art in all its diverse forms, be it classical dance, musical traditions, painting and sculpture styles, or literature and theatre. Setting up the Sahitya Academy, Sangeet Natak Academy, the National Center for Arts, School of Drama are some examples of this commitment. The establishment of the National Archives and Archaeological Survey as offices attached to the cultural part of our government to protect monuments, places, and objects of national importance is another manifestation of this commitment to protect our plural histories. The Constitution, in fact, affords as a fundamental right to all sections of citizens the right to conserve their diverse culture, language, and script. This express recognition of linguistic rights is not limited to the 22 official languages identified or the freedom to choose a medium of instruction in school, but extends well beyond it. Promotion of the scientific temperament was another key feature of the development goals for newly independent India. While there is now room for private players to enter these spheres, the state did not relegate it to the private sector. It either inherited or continues to support or established by legislative enactments, leading institutions for research and learning, like the Council for Scientific and Industrial Research, AIIMS, IITs, etc. A prerequisite for a constitutional democratic republic is the maintenance of the rule of law. In many ways, it is the most fundamental minimum, without which none of these other aspects of constitutional culture and its protection have any relevance. Every decision of a state organ has to be preceded by relevant reasons and demonstrate that some form of consultation and opportunity was afforded to interested groups that were likely to be affected. This is an ongoing project that the decision should be taken without bias in a fair and reasonable manner is a legitimate expectation that every citizen enjoys in our constitutional democracy. For instance, a proposal to acquire land requires enabling legislation. Setting up an educational institute can be approved only on the basis of existing and known guidelines. Whether the state can impose a tax and to what extent requires the backing of law and policy. Even where discretion is afforded, a decision is to be checked on that ground of proportionality and contains reasonable avenues to appeals. These are all examples of the culture of fairness which the people can justly and reasonably expect to hold their governments to. And this is not an overnight process. This has happened over a period of 50 to 60 years through interventions by court, through interventions by conscientious groups, aggrieved litigants who approached and have sought redress. The principle of fairness has gone beyond mere government functioning. It also now applies in private fields like employment. For instance, industrial law requires that no one can be fired without following some minimum procedure. A complaint regarding sexual harassment at the workplace has to be redressed, and the employer is duty-bound to take action. Privately controlled companies that perform public duties have to follow the principle of fairness and reasonableness in their dealings with the public. This is especially relevant when post-liberalization, combined with the effect of globalization, the state has transitioned from its omnipresent role of provider to a retreating state, that is, as a facilitator in many fields. The Constitution has no ideology. It allowed a centralized and controlled economy and equally a liberalized open economy. These are some illustrations demonstrating how constitutional culture situates a duty upon the state to exercise its legitimate power to enact legislation and establish frameworks and procedures to ensure private entities have similar limitations against impinging upon fundamental freedoms of individuals, and more fundamentally, to foster a culture of fairness, non-discrimination, and accountability that informs all our institutions and interactions. This is how we must perceive the larger picture of the Constitution, working in a real sense with all its minute cogs, nuts and bolts for each individual, and the spirit of fraternity at large. In conclusion, I must say the democratic discourse is noisy. The range of views and opinions expressed and the intensity with which they are voiced may make some feel that there is chaos. Yet this diversity is both a listening point and a safety wall. Listening point for governments to take note of and make changes in policies and laws, and a safety wall because the alternative of silence can lead to violence and aggression. This is the USP of the multi-party system, which takes into account the diverse aspirations of the country. As a nation having reposed faith in the democratic way of governance, we must be prepared for imperfections, but non-negotiable value which we must exercise is our freedoms. Question those governing us with us unremittingly, and through this dialogue, realize our aspirations. The freedom to speak would be lost, like all liberties, if it were not exercised robustly to question the wisdom of those who are elected to govern. Constitutions which derive enduring systems of governance for a nation are not levers and pulleys or clockwork universes that mechanically drive the people along a predetermined path to a prescribed future. It is not a flash-frozen remnant of history reaching out with its dead hand to make sure that society sticks to a preordained path marked out by its creators. Rather, it is a framework for an ongoing debate on how to best approximate the national ideals. It anchors societies in the past, guides them in the present, and offers shared aspirations for the future. The values that it embodies of liberty, equality, and justice, and fraternity continue to guide our interaction. But this is not something that can be taken for granted, for we are only as strong as our weakest link. Attempts to dilute our fraternal ties and undermine our shared histories with falsities can only weaken us. There are threats to independence of our institutions, which are further complicated by technological advancements that allow for harnessing of data in the absence of comprehensive legislation to protect privacy. I have referred to the challenges to our electoral system and the freedom of speech and expression. Constitutional culture requires us to be alive to these challenges, not periodically, but as an everyday endeavor, to keep our eyes peeled for the slightest cracks in our institutions of weakened commitment to constitutional values. The ebbing tendency towards homogenization requires strong resistance, which begins first with awareness, discourse, and debate, translating into sustained engagement and action by all when the situation calls for it. For instance, our country's response to the global climate change crisis requires nuance to ensure that policy decisions will not put populations that are already marginalized in harm's way. Forging solidarities across the spectrum when one of these constitutional values is at risk for any group is the strategy which the people should rely on. Constitution culture, therefore, requires that we are aware of what is expected of us, of what we can do, and the potential it affords us to meaningfully exercise our hard-fought rights. This is the only way to salvage and preserve the democratic and pluralistic ethos that the founders of our nation had so presciently demanded of us. Referring back to the question I started my address with as to what the relevance of the Constitution is for each one of us. It is clear that the Indian Constitution is the sum total of radical aspirations that our ancestors had for us. But it will also be the site of contest and conflict in the years to come. To remain committed to its ideals and values, to cultivate and preserve this culture it imbibes will be the only way out. The reference to the Constitution, its history and values cannot be limited to only a few dates earmarked in the calendar, but as a year-round commitment. As we completed this 71st anniversary of our nation's founding, civic education must do more than teach names and dates or even impart hands-on experience. Indian citizens today must be prepared to acknowledge our nation's mistakes, to recognize that we have over time to improve our imperfect union, to recognize that we have to find pride in these struggles, and to recognize that at our best, everyone is included. That value, inclusion, is vital for the survival of our Constitution. It also means translating the gains of prosperity, of economic progress, to the poorest, the most deprived. Our achievements, whether in setting up our institutions of learning or reaching Mars or becoming a $10 trillion economy, would be cold comfort for a large mass of people. Citizens today must be able to engage in the ongoing debate to find compromise and from it all find their own love for our country. The challenges that each generation faces may not be the same, but it is for them to find the answers within the framework of the Constitution. No democratic constitution or system of governance with any measure of people's participation can survive unless its rulers, the people, are invested, believe, and take pride in it. Taking a cue from Louis Brandeis, the great jurist, one can say that it is the people, the voters, the sovereign who matter in a constitutional democracy. The only title superior to that of president is that of a citizen. So, ladies and gentlemen, it is the people who have to keep democracy and the wheels of governance through the Constitution ticking. So long as they do, democracy will flourish, and we may witness an India at 2047 as a society which proved all its prophets of doom wrong, a strong land of freedom without narrow domestic walls and whose people hold their head high. This is the kind of India I hope all of you wish for. Thank you.
Thank you. Thank you. Thank you very much. I just want to say our time is short, so we'll have a short conversation and maybe take a couple of questions because I'm told by our organizers we have to be out of here shortly. But thank you. You know, when it went out on social media that I was going to be here with you, a few friends in India, including some whom I will not name, who practice in the court, said, you will never meet a more erudite man who's as likely to quote in, I guess, Brandeis you just did, but Dohas of Kabir and Shakespeare at the same time while ruling on constitutional law. So thank you for that talk. You know, it's very inspiring what you had to say. It's aspirational also. I think, you know, we don't have time for a long talk on the culture of constitutionality, but that is essentially at the heart of what you're saying. How we develop a culture of constitutionalism in India, enrich it, since, as you point out, we have it. And one of the things, in the interest of time, that occurs to me is recently there have been debates. If you think of judges as among the principal guardians of this culture, there's been a deep debate, it seems to occur once a generation in India, on how judges are chosen. And there have been sides picked. Of course, it's not resolved. I wonder if you have thoughts about that and how it relates, sort of what the shape of the debate is for you and what you think the resolution might be that preserves the culture of constitutionality in India.
How judges have picked now, I assume you're talking about the higher judiciary.
Higher judiciary, yeah.
So when you're talking of how judges are selected, most of you are aware that the Constitution does not speak of judges selecting judges, but this has now been the law for the last over 30 years, that the Supreme Court, in a very, let's say, a very important constitutional judgment where there's a 9-judge bench which ruled that the ultimate say of who is to be made a judge is with the 3 senior-most judges of the High Court, who would be, their choice would be approved by the Supreme Court. These are this collegia of judges. They would approve it and then the government would appoint them. And that's how the system has worked. The government wanted to, the parliament wanted to amend the Constitution, which it did. And it proposed a judicial commission, but the Supreme Court in a 2015 judgment struck down that on the ground that it violated the basic structure. Essentially, it was just the outline of how appointments would be made, but left much of what had to be done to be legislated by a parliament by a mere law.
Yes.
So that was one of the important objections, I think, which compelled the court to strike down the law.
When that was being debated, and currently the debate is up, there was a fear that the present system where the collegium decides and then the government proceeds after just a certain due diligence investigation of a very limited scope, that there's also a lot of grounds for favoritism in there, and the system is opaque. And do you feel those critiques are justified?
Let's see how it could be the other way around. Now, if you don't have this system, at least in this system, no system is perfect. If you start with that premise, then if we say there is this problem with X is the problem with this system where the system of the manner of selection is opaque. Are we proposing a system where, or how was it prior to this? Even then it was equally opaque. Yeah. At least the merit with this is, the merit of this system is that it allows the senior most judges who have the best opportunity of seeing talent to earmark and select it. There are discordant voices, and probably they're justified too, that there's not enough diversity on the bench, and probably a lot of talent is also doesn't make its way. So I suppose these are criticisms, and these criticisms have to be taken into account, because the existing system also has to reflect upon this and select.
Thank you. I'll move on to just one more thing before I throw it open to the audience. You touched on the place of the court, the culture of constitutionality, the way in which we as a society in India have been navigating and negotiating our way out of the injustices into a future. There are times when the court, both here in the US and in India, is ahead of public opinion. You could argue that in the US, the court, when it ruled on Roe v. Wade, was so ahead of public opinion that perhaps it took, 2 generations, but that was in the end reversed. In India, we've seen a lot of debate over certain kinds of court rulings. Parliament has overturned or disregarded some reservations, Shabana case, a multiple set, recently we've had a series of rulings on homosexuality in which the court also changed its mind a little bit. I wonder, how do you think about the role of the court vis-a-vis society, and the court being in the vanguard or not of public opinion? And is that also sustainable?
Now, public opinion becomes a very nebulous and dangerous concept. Should courts heed public opinion? After all, when we are talking of constitutional and the constitution and constitutional value, what public opinion? Are you looking at contemporary opinion? Or so public opinion ought to drive other institutions like parliament and the legislature and policy makers. So they have to accommodate the views and the challenges which are faced by society and find out solutions. Judges, the judiciary is more of a at the other end where policies are reviewed, and they have a certain standard, that is the constitution or the legislation in question. And what you say is something being overruled, like the parliament's law is struck down. The system of checks and balances which exists both in the US and in India is such that if the law struck down by the court is such that can be remedied and capable of being cured, then Parliament would reenact it. Or if Parliament does not agree with the ruling within the framework of the Constitution, as long as it does not attach to a constitutional value, then that ruling can be overridden by Parliament. So each acts within its own sphere. So this conflict, as you see, it is not really so. This is how the Constitution was meant to work out. So if there is, I can give an example, for instance, where the courts have gone forward and filled the role. We could even say that the courts have legislated, for instance, when it came to adoption, inter-country and interfaith adoption of children. For the longest time, there was no law. And that law, the law or the set of guidelines were framed by the Supreme Court. They were even acted upon by the executive, and that formed the framework for the law. Likewise, when you come to the law on sexual harassment at the workplace, there was a vacuum. The Supreme Court ruled on this and again framed a set of guidelines. It got accepted and made into a law 16 years later. So this is part of a dialogue. I would see it that way, that it's part of that dialogue. If there is a disagreement by Parliament or the state legislature, they step in and remedy that, or they overturn the ruling.
Thank you very much. And I see a theme running through all of your comments in which we all have responsibility. And it's shared. I'm sorry we're out of time. I want to thank you all. I want to thank you, sir. It's really an honor to be here with you. And just very briefly, I want to thank the organizers for an extraordinary day. As someone whose hair is now graying and is in his late 50s, I want to say all the tropes we have about young people and Harvard students being incredible have been proven true by what you've done today. The depth and variety of the conversations has been staggering. So thank you very much.
Yeah, thank you so much. And thank you, Justice Bhat, for your insightful remarks. I don't think we could have asked for a better end of the day for the HKS day of the conference. I would also like to thank Hitesh for helping pitch in and moderate this chat. Before we end for today, I would just like to thank all of you lovely panelists, or not panelists, attendees, and all the panelists who joined us today at the first day of the conference. I would also like to take this opportunity to thank our supporters quickly: title supporter WNS, brand supporter Zydus, other supporters such as Lakshmi Mittal and Family South Asia Institute, Light Stage, Wadham, Ash Center, and Joint Center for Housing Studies at HKS. Finally, we're really hoping and excited to see you tomorrow at the Harvard Business School for our second day of the conference. And yeah, thank you so much. Hope you have a great evening.